you think needs more clarity?
Needs more clarity, yes. And also because revocation is a more elevated response above suspension. And we also consider that the decision that the minister would need to take in relation to revoking a license would have impact for the public interest, it would have impact for the national grid. And therefore, it's something that we think should be approached more carefully, and a better justification be set up for the minister to be clear in how to exercise his authority in making such a decision. And in respect of section 13.6, we do not see how the minister would be so placed to make a decision concerning the revocation of a license.
In relation to subsection 6?
Yes.
So if a licensee or the single buyer breaches the agreement, which leads to a concomitant breach of the license, you're not seeing how the minister would be placed to revoke the license? Is that, I'm trying to understand clearly what you're saying.
Yes.
Okay. And what would you want to see to allow the minister to exercise that authority if he were so minded?
Okay. Perhaps we would need to identify what type of actions on the part of the single buyer or the licensee would amount to a revocation. It would have to be something that is material, of course.
Mm-hmm.
But so that, in my mind, would be something that we would need to see. I know that at sections 13.1,
Mm-hmm.
it refers to the Bankruptcy Act.
Mm-hmm.
And that could be one of the considerations. It could be that there's a principal in one of the licensee companies who may be convicted of a criminal offense. And in relation to that conviction, if it would materially affect the operations of the single license, the licensee's facility, in such a way that the licensee would not be able to perform in an efficient manner or to the required standard, the terms of the license or the related agreement.
So let me ask you this, Ms. Campbell. Chair, if you could indulge me just for a moment. I'm really grappling with this. The license that is granted under the Act,
yes,
does it contain an express term that, to the effect that a breach of the agreement between a licensee and the single buyer will constitute a breach of this license, or does a breach of the agreement become a breach of the license simply because of section 13? Are there express provisions in the license itself almost identical to what we're saying here?
The license contains the provision is in the agreement, not the license.
What provision is in the agreement?
So in terms of, okay, so let me just say that these agreements we do not have access to. But based on my discussions, I understand that there are provisions setting out what should happen in the event of revocation or suspension. Now, the typical...
I'm sorry, what should happen in the event, what should happen in relation to the agreement between the two private parties in relation to revocation or suspension of either license?
No, in relation to the activities that are to be carried out under the license.
So there
And
are provisions in relation to breach of the agreement.
Breach
as
of the
between
agreement.
the parties. And just to confirm, these these agreements would have to be agreements reviewed and sanctioned by the OUR. Am I correct in that?
That is correct.
Right. So as of now, we don't really know if there are express terms in those agreements that say what we are saying here in section 13, that if the agreement is breached, the parties acknowledge and understand that that their licenses are also in breach, right?
Right. So that's my understanding, but we've not seen it.
I take you with the limit that you're creating in what you're saying. Here's the trouble that I'm having with this. I think I agree that in relation to a breach of the agreement, if that automatically creates a breach of the license, which is what we provide for under subsection 6, then if that then makes the party subject to a revocation, if the minister exercises his authority to do it, I agree that that would need to happen in respect of material breaches of that agreement, something which materially affects the license. So I'm agreeing the inclusion of that. But this part about the process of revocation, process of suspension, section 13 sets out what amounts to that process to address the concerns about how you deliver natural justice and how you execute, or how the minister exercises his discretion in consideration of the public interest. And if I could just take you to section 13, subsection 3. But, well, before I do that, let me take you back to 13.1. 13.1b, which is the one referred to in subsection 6, is the part that talks about if the licensee has breached any of the terms or conditions of the license and the period provided, if any, for remedying the breach has expired and the breach has not been remedied to the minister's satisfaction. So that's one of the grounds on which the minister can exercise his discretion to revoke or suspend. But bear in mind that if you arrive at 1B by virtue of the fact that you, as a party to the agreement under subsection 6, if you have breached the agreement, the breach of the agreement that any provisions for breaching the agreement would and should contain provisions for remedying the breach before. So what I'm trying to say is we have termed this here a breach of the agreement just by virtue of a party not doing something that they should have done under the agreement, right? Or doing something that they should not have done. Mm-hmm. But the agreement would contain periods of time to allow a party to remedy a quote unquote breach if they were minded to remedy it, right? So that you can't begin to act on that agreement until you have given, perhaps, and the usual provisions are you've given notice to the other party that they have breached, and the party is then given 7 days, 10 days, 30 days, whatever amount of time to remedy the breach. And then if they don't remedy the breach, then you can act. You can take action in relation to the breach, but that time period has happened. So are we saying here in subsection 6 that a breach of the agreement is by not observing some provision simpliciter, Or are we saying that having breached and having had time to remedy that breach under the terms of the agreement, it then constitutes a breach under the Act? That's a little bit of a confusion for me. So that's one thing. Subsection 3, if I can move to subsection 3, speaks to the concerns that you expressed in relation to the delivery of natural justice and how the minister exercises his discretion in consideration of the public interest. And it provides, subject to subsections 7 and 8, which is the sections when considering suspension, where the minister has to notify the licensee, give the licensee time to remedy the breach before he can act. Subsection 3 says he shall not exercise his power to revoke or suspend an electricity license unless he has first afforded the licensee the opportunity to make representations, whether orally or in writing, as to why his power should not be so exercised. That's the process. Whether it is suspension or whether it is revocation, subsection 4 says he may appoint one or more persons to hear, receive, and consider the representations referred to, and to submit to him for his determination within such specified time as he may consider reasonable a written report of the findings and recommendations. It's only after that process, so in other words, the breaching party or the licensee in danger of revocation or suspension under 3 and 4 have a process to make representation to the minister to be heard before the minister can take any decision. So I'm a little confused about your concerns about the absence of a process. But I agree with you that there is some tidying up that needs to be done in subsection 6. And I also concede your the point I raised the last occasion, which you mentioned earlier, that may does not substitute for shall in the context of what we're trying to do. But I am now, I think, still puzzled by where it is the OUR wants us to go on this. I still am not clear what it is that they wish for us to do. When they say unremedied breach of the agreement, it seems as if they may in fact, I may in fact have just come over to where they are, because I think that's exactly the problem I outlined before.
Chairman?
Yes, member, go ahead.
Yes, I'm trying to understand as well this provision, and I do want to comment on an aspect of it later on. But my understanding is that these agreements that were in existence before 2050 are those that this provision is seeking, or this proposal is seeking to catch, because the law in 2015 did provide for, we presume, new agreements. If that is the case, I would have a difficulty with the OUR's recommendation. And of course, the issues related to suspension and revocation, those processes are outlined, which do have regard to the whole principle of natural justice. But I have a fundamental concern about these agreements. These agreements are mainly power purchase agreements. There are others, but they are mainly power purchase agreements. And I remember one of the reasons why we wanted to review this law was of my own concern about the secrecy of these agreements. Earlier on, you announced the meeting that you, the minister, you have to write to the OUR to be able to see an agreement that affects the lives of our people. And I too would have been so hamstrung when I was minister. I believe in this day and age, these agreements should be public. People say that, you know, you have proprietary issues that need to be preserved. Well, you could always deal with those, but I believe that the fundamental commercial terms that last for 20 years, because these power purchase agreements affect us for 20 years, we should have a policy that the public would have a right to see them. Because what the OUR is saying is that where there are breaches that are unremedied, then you as minister should revoke or should suspend. But you have a right to know what these are. You shouldn't have to be writing to the OUR to get a copy of the agreement between the JPSCO and New Fortress when you have to issue the license for that body to operate. So I think we need to consider that, Minister, and to take a position that these agreements ought not to be private agreements between two enterprises, but you as minister, indeed the country, ought to be privy to the terms of these agreements that affect people's daily lives.
Minister, may I make a comment in a similar vein?
Go ahead, Member Wilson.
Thank you. My apology for being a little late. I want to join Member Paulwell in those comments. And while we are all understanding that these agreements have to be handled with a degree of sensitivity in regard to some of the information that may be in there, it certainly cannot be that the minister with responsibility is off limit to the minister when it's already in the executive in the OUR, and the same protection that binds the OUR would apply to the minister and how he handles those agreements. But I go further to say that I believe it fundamentally must be understood by JPS and whomever else, because it doesn't obtain anywhere else in the world, that the parliament of the land must have access to those. And its parliamentary committees, and I'm not talking necessarily about public hearing or public release of that, but surely we have provision in our parliament handles sensitive information. And so, Minister, it's beyond, when it came to my attention that you had to write, and that the parliament and that nobody other than JPS and Fortress knows the content of that agreement other than private lawyers that they would have both, and the OUR, it is unacceptable. And it must be established that the parliament and the minister has a right to those documents. It must be. You can't be doing business in the country that the parliament doesn't know anything about and can't have access to. And the minister who is responsible for, as a member Paul says, for issuing licenses and taking other actions is off limit. Unacceptable. Simply unacceptable. And I don't expect that there will be a rejoinder to that. And I'd like to hear the different views if it exists.
Thank you, Member. Any other member want to come in on this particular matter?
Mr. Chairman, on this particular point, I intuitively know how protective business people are in relation to the agreements they enter into. And I understand that, and I understand why. But further to what has been expressed by Member Hilton and Member Paulwell, may I ask a question? When an agreement is breached between a licensee and a single buyer, how does the OUR how is the OUR put on notice that there is a breach? I am not clear on that because we have created a system for revocation and suspension on the basis of a breach of an agreement, which the OUR under section 14 says it must notify the minister in writing if there's a breach of any condition of the license, the codes, the act, the regulations, right? That's not the agreement part. That's the license, the codes, the regulation. But of course, under 13, if you breach the agreement, you breach the license. But how does the OUR know that there's a breach of this agreement between these two private interests in order to trigger the entire system?
My understanding is that because the OUR really is the custodian of these agreements, and again, I think that role has to be queried because the OUR doesn't sit in the room when the negotiations are taking place, and in a perfunctory way gets these agreements, and it is the regulator. So it is called upon from time to time by either the parties to resolve issues. And it is at that stage that they would seek to be involved in remediation or whatever, and after which they would presumably ask the minister to exercise its authority to suspend or revoke. But the OUR is not an active participant, and probably quite rightly so, in those negotiations. It is aware of the terms because it has custody of these agreements.
So Member Paulwell,
yes.
So we're essentially saying then that these provisions really rest on the election of the parties to the agreement. So if they elect to advise the OUR they're having a difficulty, then this act is triggered. But if they choose to handle a matter of dispute privately, we would not necessarily ever know.
You're absolutely correct. And it then brings the question whether or not the OUR is not proactive enough, because the OUR really ought on its own in policing these agreements should, where they see blatant acts, and either the JPS, we speak of them of single buyer, but let us call it what it is, the JPS and other licensees. If the OUR seems not to be able to enter into that agreement and say, listen, you two, both of you are behaving badly and your licenses ought to be suspended. It is only provoked if one of the contracting parties has a fundamental disagreement. And I agree that we need to look at that entire structure and either give the OUR more power to police the terms. I suspect it does have the power. So we'll have to urge the OUR to be far more proactive. But more importantly, the minister and the country. I go further because I believe some of these sensitive terms can in fact be redacted. But the minister must have access to these agreements.
Chair, just on the back of that, and then I will close and shut up for a while. You know, everything that has been said, and even in looking back at this between the last minute meeting and today, I am really wondering if in this review committee, whether we are doing ourselves and the nation a disservice by not also looking at the act governing the Office of the Utilities Regulation, because these two are so intertwined that I don't, it seems to me that in reviewing this, we ought properly to have been reviewing the other as well. Mentis.
So I want to touch back on Member Hilton and the fundamental issue that he raised in relation to the agreements being in the possession of the OUR and the ministry/minister, and by extension, the parliament has no access to it. That to me is a fundamental issue that has to be resolved. And I heard support Member Paulwell.
No, sir. Just a point of order. That is not so. I made the point, and Member Hilton supported it. I just came back in to further give credit to emphasize what I was saying earlier. But it's a matter that affected me when I was minister. Yeah. And I believe that it's a fundamental issue that ought to be addressed.
And I fully agree with both Member Paul and Member Hilton in relation to that. And I don't think that is in need of any long debate as it relates to that. I don't know if there's any other member that wants to have an input on this particular matter.
Could we get the OUR's view on it? I'm sorry.
Oh, Chairman, morning colleagues. I just want to record my strongest endorsement of the point made by colleagues Paulwell and Hilton. You know, at the end of the day, after all is said and done, it is the minister of the government that is ultimately responsible to the people in what service is provided, and by extension, the terms under which those services are provided. And no minister can act out of ignorance of what the provisions are. You know, it's just unthinkable. Those should not even have been contemplated in the first instances, more so to put it in agreement. So I just want to put on record my strongest support for that.
Minister, the situation is, of course, grave when you look at the sector and the monopoly that is accorded to the sector. And therefore, I think it's just impatient, and we should not have allowed it in the first place.
Point noted. Remember, Paul, you were asking about the OUR?
I'm just thinking as we're going through this process, Minister, where we're contemplating some of their recommendations. It might be useful to have them present. The OUR is a fundamental part of this apparatus, you know, and I don't know if they are present, by the way, but they should be present. Yeah. And especially as the question was raised of their own legal and regulatory framework. They should be here to speak to that. I can say it because I was a part of the amendments that were done to the OUR, that the OUR has tremendous powers, and they can do so many of the things that we are speaking about now, not only to be like a supervisor, but can be actively involved in ensuring the protection of the Jamaican people. But it would be good, Minister, if they are present during these deliberations.
I agree, and Member Golden made a point that really should be considered, that in a sense to review the act and the main actor, one of the main actors, is not a part of this. Or she suggested that we should be looking at how would be perhaps consequential amendments flowing from that for the OUR, for the act itself, the OUR constitutive legislation. But that's for you to consider, Minister. But I agree, Member Paul, and I'd love to hear the OUR's view on this.
All right, members, point taken. We will invite them for the next meeting. I don't think they're on here, but we will write them and raise the issue for them to come prepared to respond. And at that point, of course, we can have a final position taken by the members. All right, Ms. Campbell.
Section 14. Section 14 provides that if the OUR is satisfied that an electricity license is contravening, is likely to contravene, or has contravened any condition of the licensee's electricity license, any of the codes, any provisions of the Act, or any regulations made hereunder, or any directions issued by the office to or applicable to the licensee, the office shall forthwith notify in writing to the minister thereof, and may provide the minister with such recommendations as it considers appropriate. In our review, we considered that there is need for more coherence between sections 13 and 14. Because we believe that the investigations carried out by OUR in relation to the activities outlined here, or any action taken, has some affinity to the powers of revocation and suspension that the minister has in section 13. It is our view, therefore, that the OUR is to be vested, it should be expressed in section 14 that the OUR is empowered to investigate and to monitor the licensees in relation to their adherence to the electricity license, any codes, and the Act, and any regulations made under the Act, or any directions as applicable. We also consider that OUR in undertaking the investigation, that it should be expressed here that they should have powers to request information in relation to their activities under section 14. They should also to request information or to interview anyone of interest in relation to their monitoring under section 14. We also considered that the OUR should notify the licensee of any contravention, setting out the particulars and requesting that they provide justification, or they may direct them to undertake any remedial action. We consider that this is prudent because in the final sentences of the section 14 provision, the OUR is to notify the minister and provide the minister with recommendations as it considers appropriate. And these recommendations should also inform the minister whether or not in relation to any contravention of the Act, the regulations, the code, or the license, based on their findings, what their recommendation to the minister is in relation to whether or not there should be action taken to suspend or revoke a license. We also considered that the circumstances here should also be placed. For example, the contravention of the license, the code, should also be included in section 31 for the minister's consideration in relation to whether the grounds should also form the grounds rather for the minister to act in relation to the suspension or revocation of a license.
Hello?
Chair, is there any?
Ms. Campbell,
Yes, Chair.
sorry, I didn't get the last part. What did you say?
I was asking if you could invite the members to comment if there is any.
All right,
I was
members.
really trying to digest all Miss Campbell just said.
All right.
I'm sorry. So to be clear, Mr. Campbell, what is the bottom line proposal?
So the bottom line proposal is for the OUR's exercise of powers here, the breach of the code, the electricity license, to form.
To have the power to do what? We have to have the power to investigate.
Yes, because it's not manifest on the surface. So we think that they should be specifically empowered to monitor for compliance.
Mm-hmm.
And it should also state that the OUR may also act in relation to the activities here. They may also act on representation from any person in relation to licensee's activities under a license in respect of the adherence to the code and the provisions of this act or regulations, or in relation to any directions that they have issued, the OUR has issued.
And that now doesn't exist?
Not in this act.
But it does exist in the OUR's Act. Because in the OUR's Act, they do have the power to inquire into concerns they may have in relation to licensees. And they have a whole scheme of how they are to engage at inquiry, looking almost like a quasi-judicial inquiry. I am not, Chair, I am not opposed at all. And I do see the need for the OUR to be able to investigate. After all, if you are the regulator, then that has to be a part of your role and function. You must be able to investigate if you are going to make any kind of recommendation or ask licensees to comply with any particular direction. I think, so in principle, I am in support of that, but I think the team would definitely need to look at the OUR Act to see how their powers are set out there, and be guided in terms of how we're looking at it here, which is the caution of the OUR, I believe, in the proposal that they made as well.
I would agree with that. It seems to me, as Member Paul said, and I wonder if he's still on, because he should be able to confirm, but I believe that to address the OUR's powers in this act, you would have to, first of all, have reference to their act to make sure that whatever we do in this act is at least coterminous with and not in conflict or derogation from their act. So I would expect that should be an important part of the exercise.
If I may, comment, Chair. I did look at the OUR Act, and I would also wish for the OUR to confirm whether it is so. But we thought about this provision because when we read the OUR Act, a licensee is a person who was issued with a license pursuant to 4B. And in 4B, it says that applications for a prescribed utility service shall be made to the OUR in the prescribed form. But in the Electricity Act, even though electricity is a prescribed utility in the schedule to the OUR Act, the applications for electricity license, they are in fact made to the ministry and not to the OUR. So there was some doubt in my mind, and we thought that it wouldn't hurt to include it here, but we are willing, the ministry is willing for OUR to confirm if our interpretation is so. And further to what the members have been saying, then we would be certain, having heard from them, whether or not they have those powers under their act and whether or not we need to replicate it here. But when we looked at the provision, we looked at the OUR Act and came up with our recommendation, we didn't see where it was explicit that the OUR would have that particular jurisdiction in relation to a licensee under the Electricity Act, because of the point I made that the applications are not made to the OUR. And in the OUR Act, the licensee is defined as a person who makes the application to the OUR directly.
Okay. Yeah, I think that clarity is needed. I would suggest we still have, I mean, I understand your position and how you come at it, but I believe that even if we're gonna act, we have to, the second point I make is that we should ensure that in doing so, it does not conflict with or undermine or detract from. So I think that is also an important part of the exercise.
So can I suggest that we include that in our correspondence to them, so that when they come, they will be in a position to respond to that as well. So we can just deal with both 13 and 14, and obviously we can finalize at that point. Ms. Beckford, note that for me.
Yes, Chair. Noted.
Minister, may I make a suggestion?
Sure.
I just want to suggest that, having regard to the point earlier made by the observation earlier made by Mrs. Golden Campbell, that I'm a little surprised, maybe because we've broken for so long and we're coming back, but I really think this exercise, the OUR should be part of this, a standing part of this exercise, because so much of what we are proposing to do touch and concern them and their own legislation, that they should be standing part of this, so that the discussion, this writing to them and waiting, I mean, this could have been answered right now and then to make, to progress the work more efficiently.
Sure. I will make sure that goes after them. And obviously for the continuation of it, have somebody from OUR at these meetings to be able to respond. Ms. Beckford, can you confirm whether or not OUR was invited to be on this joint select as the other entities were?
No, Chairman. And remember, I'm new to the committee, so I was not of the understanding that they would have been a part of the technical team that would be needed. I worked from the list that was sent out previously.
All right, so please to coordinate with my ministry and to make sure that letter goes out to them, and obviously to advise them as to what they're coming to deal with at the next meeting.
Okay, Chairman.
All right, Ms. Campbell.
So we went up to 17 the last time, so I think it's moved to 18 now.
And that's 17 out of 29, no?
Yes, 29.
Okay. Proceed.
Okay. Section 7. So section 18, the comment from the Jamaica Chamber of Commerce. The self-generator is required to maintain an electricity system in accordance with the generation code. This is arguably not the standard to hold a household or commercial personal generator. There are other acts which confer standards and duties of care on these categories of generators. Note the fines for not adhering to the code on a self-generator is the same as that of a system independent power producer. So we understand from the workings of the technical components of the connections under the agreements for supply of electricity to the grid, that the codes are the guiding principles for the safety of the grid and to ensure efficient supply. Now we take the point that the JCC raised in relation to a self-generator being made subject to a fine for not complying with the code. And this particular provision is at section 47, subsection 4 of the Electricity Act. It says a breach of any of the codes by a licensee or a self-generator who is not a licensee shall constitute an offense. Under the current structure, a self-generator who is not a licensee, so you are generating electricity for your exclusive use, there is no requirement for that person to have a license under the Electricity Act. And we agree, therefore, that because they are not allowed to have a license, because one of the conditions is if you are issued with a generation license, then you must comply with the generation code or whatever other standards are there. And because this is not the case in relation to a self-generator who is not issued with a license, then we consider too that they ought not to be held to an offense, because they do not have a license.
May I, at this point, Minister, suggest, as I've always done, and here let me be very clear. I mean, the position that I've articulated has been consistent over time. It started when I was Minister of Industry and saw the problems as it relates to the Special Economic Zone Authority and the Special Economic Zone Act. That in devising that act, sufficient care was not taken to ensure that we have an integrated and coherent approach to this, so that in the act, in the SEZ Act, they're allowed to developers are allowed to self-generate. But no provision subsequently have been made to really carry through and address some of the issues that arises from that. And here I want to be very clear and to declare interest in this matter that I now represent a potential developer in the SEZ. And I want to put it on record that I represent them as a consultant. And this issue is one of the major potential deterrent of investment in the sector. So I'm fully aware that this is coming back to haunt us. And I think we therefore need to address the situation of the Special Economic Zone Authority, because apart from, I held the view as a former minister, I've articulated it consistently, and I'm here articulating it because, and especially if you're the Minister of Industry Investment, how we resolve this issue will have a direct bearing on a level of investment in this SEZ and therefore the growth and development of our country. This is a fundamental issue and it needs articulation. And I don't see how we can come again to review the act after the years of experience. And Minister Paul, who is very familiar with the issue from the time we were in cabinet together, will tell you that it may have been expedient at the time to just sort of say, well, let's see how it develops. But now after over 20 odd years, we now have some experiences, and we therefore need to take fully into account the fact of the self-generation that is made possible under the SEZ Act, and to carry it to its logical conclusion. And I put it on the table, and as we go along, and this provision, this Section 18 touches on it, and how we resolve the Section 18 issues, I'm suggesting have to take account of that reality. So far, it's not.
Thank you, member. Ms. Campbell, maybe this would be an opportune time for you to just give your initial feedback from the legal standpoint in relation to the discussions that the ministry is having with SEZ. It's still, as I said, we're to get something formal, member, which I expect to get any minute now, which I will table at our next meeting for further discussion. But since we're on this and you have raised it, maybe Ms. Campbell can just give you her initial response to what she has received from the SEZ from a legal standpoint. Ms. Campbell?
Sure, Minister. So the SEZ authority has responded. They have indicated that there is an interest, as was communicated by the members to the committee, for the developers to provide electricity for sale and transmission to occupants within the zone. The Electricity Act does not permit the sale or the supply as is contemplated. The SEZ Act also does not allow it, and they are only allowed, the developers rather, under the SEZ Act, and this is in harmony with the provisions in the Electricity Act. They can self-generate.
Could you repeat that last part? I didn't hear that quite. It's no harmony with what? With what?
With the provisions in the Electricity Act, the section 47, I believe, under the SEZ Act, only permits the self-generation of electricity by the developer. And they are not allowed to sell the electricity to anyone else other than the single buyer. And for that, they would have to enter a net billing arrangement. So, and we may also recall that the JPS license give the JPS exclusivity in relation to supply, transmission, distribution. So we would also have to grapple with that and the provisions in the Electricity Act and the provisions in the SEZ Act, which coordinates with the requirements under the Electricity Act.
But first of all, may I say this, Minister, and again, just for the record, for us to begin to think through the problem in a coherent way. First of all, the license, we have to look at what the scope of that license and what it applies to, because there is the reality, which I am well aware of and articulated then, when as minister we developed the SEZ Act, we recognize that the Act covered and created in Jamaica a distinction and a space between the custom zone, which is the SEZ Act, and the rest of Jamaica, because activities in the SEZ for the importation and exportation of products into the SEZ is not considered to be importation or exportation from Jamaica. That SEZ is a special zone created. And so we have to look at that legal construct that is created globally, and that's available in the WTO under the WTO arrangements, and SEZs proliferate globally. I've noticed in my reading that you have made reference to India and what India does. I would invite the committee, and certainly you, Ms. Campbell, to look at what India does with SEZs. And not only India, Indonesia, South Korea, everywhere it is addressed differently from Jamaica. And what we have done in Jamaica is to really leave a situation where developers making their own investment in generation, bringing their own clients to Jamaica in many instances, because Jamaican, remembering that under the SEZ Act, established Jamaican entities cannot go into the SEZ, cannot. So this is not a case of cannibalizing or the potential of cannibalizing existing clients of the JPS. These therefore have to be new clients brought in by the developers themselves into the SEZ. And what we have done, Minister, just to be very clear to the members, what we have done, which is an injustice, and not only to the developers, but to ourselves as a developer, as a country seeking investment and development. What we have done is to say that the developer should come in, they should spend all the money, invest all their money, put in all the equipment. Because again, we're not seeking net billing. They're quite content in supplying to their zones, to their occupants. We can confine it to the occupants, and that is the occupants is carefully defined in the SEZ Act, and does not include, as I said before, importantly, does not include customers of JPS currently in the domestic economy. Does not, and that was carefully done. But the effect of what we have done, Minister, is that we have allowed we have said to the developers, come in, invest your money, you can generate, but only for yourself, And that only takes into account a single entity SEZ, where the act itself provides for multiple users, occupants in the SEZ. So I'm really saying that we have to address and begin to address this issue, because it is having a negative impact on investment that are beyond single users of SEZs. Right? And so and at the same time, here's the anomaly, Minister. We have allowed large users, or those who have the ability in the domestic space, to come off the grid. But that people who we're inviting as investors to the country, they must now come find all the money, develop the parks, bring their own clients, and then turn it over to JPS and say, here, give us this bill that makes us uncompetitive. Nobody is prepared to come under those circumstances. Nobody. And we would have wasted our time and created a system that can only work for the single user in the SEZ. And that was never the intent. So we had from the beginning not only single users, which incidentally is the exception, not the rule, as defined in the SEZ Act. The single user is the exception, meaning that the objective for the SEZ was to create the multi-user parks. And so, Minister, that is something that I've been passionate about from day one. I remain passionate because I believe, outside of whomever I represent now, this is just evidence to me that this cannot work in the way that it has been designed. It is not fair, it's not just, and it's not logical.
Minister, if I could comment as well, if Member Hilton is finished.
Sure. Yes.
Chairman?
Right, Member.
Yes. All right. I want to support the comments made by Member Hilton. When I became Minister of Energy for the first time in 2002, there was, in fact, the JPS license in existence. And everybody knows that my inclination has always been on the side of competition.
Correct.
But the license did make a very clear distinction between competition on generation, which is the production of electricity, and the issue of competition in relation to transmission and distribution. Because on transmission and distribution, it seemed explicit. And so my entire aim being in that chair was to see how we could diminish some of that power, the monopoly power, and to incorporate competition. And there has been some success in that we're able to get people to appreciate the importance of renewable energy, and net billing was therefore a feature, and wheeling has become a feature. But the issue that was raised just now by Member Hilton is quite important and fundamental, because in my own interpretation, and I didn't come to this just as because of my background in the law, but just practical. Before this special economic zone regime was established, we had a free zone regime. And there is little distinction between the two. You operate in these zones as if you were a foreign enterprise, because these companies are producing goods and services exclusively for the export market. So you're seen to be competing with the world in terms of putting you on the same footing as if you existed outside of Jamaica. So persons in these zones, in these special economic zones, are not considered to be a part of your local customs. And I saw a clear distinction between the operations of JPS in Jamaica vis-a-vis the operations of JPS as it relates to enterprises that are considered to be not in Jamaica, not in the custom territory at any rate. And it has never been tested because I believe that the OUR has come down in support of the JPS proposition. And I'm not soliciting work as a lawyer, but I contend that if that were to be tested, then the results could be startling in that it could carve out for the enterprises in exclusive zones a clear demarcation between them and the custom territory. But that notwithstanding, Minister, I have been urging you as we now approach, well, two things. We're approaching the end of the license, and yes, 2027 seems some distance away, but it is not in terms of planning for the future. The JPSCO must now be engaging you in some negotiations. And I believe it is full time that some leverage be applied and some concessions be given. We are not going to get companies coming here in droves to increase our GDP in these exclusive zones if the price of electricity is as it is now. They are not. It is just doesn't make sense. Perhaps the BPOs will remain competitive because of the competition that exists in terms of telecommunications. But it's not going to last forever with the price of electricity as it is now. So something has to give if we are going to see the explosion that was contemplated with the establishment of these zones. It is important that some leverage be utilized now to get that as a concession. And this process that we are engaged in, I think members would support the inclusion in this review that we're doing in the new law to come for there to be liberalization of this area within the special economic zones. And you might very well have to concede on a certain effective date. So it probably can't be the 1st of May 2023, but it could be a date that would precede the 2027 termination of the law. I think it is worthy of debate, having regard to the important economic objectives that the country is seeking now to derive.
Point well taken, member, both member Hilton and member Paulwell. I think what Ms. Campbell was speaking to more is the legal ramifications, and I'm sure that at some point that will have to be a part of it, even if it is that we were able to get some concessions from JPS in relation to this particular matter. I am wondering, as we are doing with the OUR, if this shouldn't be another discussion directly with the SEC management chairman and minister responsible. What's your thoughts on that?
No, I mean, I'm fine. I would imagine the SEC would see it the same way. They know the challenge they're faced with in securing investors, because this matter comes up time and again. And when once persons understand that they'd have to be subjected to making massive investment, bringing in clients, their own clients, and then turn them over to the JPS to really put on punitive rates on them, then they just stay away and they move on. And they move to Dumrep or some other place.
100%. And it's something that you've been speaking about for
many
a very
years.
long time, advocating for a long time. So I'm in agreement with Member Paulwell as well that I mean, at this point with this review, we should definitely have some direction on it in terms of a policy direction for sure. So what I will do is I will Member Paulwell and Member Hilton, we can speak, and then obviously Member Hill, who is a member of this committee, is not here today, but I'll have further discussions with him as well. Ms. Campbell, you were speaking about the legal implications.
Minister, let me just say, on that, there's no debate. I mean, the current situation is just what it is. The whole purpose of this exercise in looking at the act itself is to begin to, at a minimum, begin to signal your policy, a shift in policy. And even under the act, if the JPS in the license and the license itself comes up for review, but as Member Paulwell says, if the ministry makes clear or the government makes clear its policies it's for the JPS to understand what time of day it is and where the country is going and resolve to go. And it's for them to decide whether they want to subject themselves to a challenge, and that may come not necessarily from government, that may come from the private investors themselves. So they must understand that this situation is not the law. They may have a handle with the law, but it's not consistent with policy because the policy itself was not coherent.
Fully understood and accepted, member, for sure. A policy direction will be discussed and given on this matter, and then we take it from there in terms of what are the next steps. But yeah, definitively, I'm in full agreement that there's no better time than now in relation to bring this thing to a logical conclusion in terms of timelines, if necessary, as to how long it will take, but to get it moving from now. Mr. Richardson, remind me to have a discussion with yourself and PS in relation to this and the policy aspect of it with Minister Hill. All right, Ms. Campbell, you want to continue on the legal aspects that you've found?
That was a summary of it, Chair. So the SEZ Act, the Electricity Act, which are saying the same thing in relation to the generation of electricity for sole use, or unless you're going to be a net biller and sell to JPS or a wheeler. But those are the considerations from the legal perspective, and the SEZ admits that the Electricity Act and the SEZ Act would need to be amended.
Okay, noted. Proceed, Ms. Campbell.
The JCC also expressed concern that under the wheeling arrangement, an entity is allowed to wheel power to a subsidiary or another entity in which it owns more than 50% interest. But their concern is that the Act requires that power be transmitted and distributed through JPS, and it contravenes the objective of competition and efficiency. So our response to this is that so even though there's a single buyer and the exclusivity for the single buyer under the license is to supply, the JPS under its license have exclusivity for transmission and distribution activities. So even though we do appreciate the concern raised here, we do recognize that the exclusivity under the license would prove problematic if the power is not wheeled through their distribution or transmission system. Continue, Chair.
Yeah, just continue.
Okay. The OUR, in its comment on section 18(1)A of the Electricity Act, says that in their interpretation, it seemed to require all self-generators, whether or not connected to the grid, to abide by the generation code. Since there is no requirement, they continue. For licensing or registration, unless there is connection to the grid, it is not clear how this requirement will be enforced. And they recommended that it be deleted and the provisions regarding the duties of a licensed self-generator be addressed in section 17. That recommendation is agreed, and we also made the recommendation in section 17 under the discussion last week, that in section 17 be made to apply to a generation licensee and a self-generator who is issued with a license, as requiring them to abide by the generation code. Subsection 18(2), the use of the term supply in section 18(2) is unclear on 2 grounds. This is a comment of the OUR continuing. In the first instance, we are saying that the term supply already contemplates the sale of electricity, and therefore the use of sale and supply in the provision is superfluous. Secondly, supply should not be used in the context of self-generators because they are not permitted under the Act to sell electricity to consumers, which is a key component of the definition of supply in the Electricity Act. They may only generate electricity for their own use or sell to the single buyer. Now, the definition of supply says, with respect to electricity, means the activities involved in the sale of electricity to consumers. Now, we agree with the OUR's observation to the extent that it applies to net billing arrangements. Under the net billing arrangement, excess electricity is allowed to be sold to the JPS, and that from the JPS will be made available to customers or consumers. Now, we do not agree that the term other supply should be eliminated from the provision of section 18(2) because there is the wheeling arrangement, which contemplates and in actuality provides for electricity to be supplied to one or more of the wheeler's location or to an entity in which the wheeler, who is the generator, wishes to have wheeled to that entity. That sort of activity, we are of the interpretation, is considered supply and ought not, and in that sense, the phrase ought not to be removed from section 18(2), contrary to what OUR is proposing. Chair, are we considering or should I?
No, I was commenting, sorry, that I'm supporting the interpretation and the position by Ms. Campbell and her team. For the reason she articulated.
Noted, member.
Section 18, subsection 3, the OUR in its comments has indicated that the section should not be restricted to self-generators only, but to all licensees whose generating facilities comprise the merit order. Also, the provision does not take into consideration the provisions of the interconnection agreements and the codes, which would also allow the system operator to protect the grid and deny access to licensees. They continue. For section 18.3, it is proposed that a general provision is inserted at an appropriate section of the Act as follows. Except as provided for in the codes, licensees shall not be denied access to the system. In our deliberations at the ministry, we agreed that the codes should cover all the self-generators who supply power to the system, and we agree that the provision should be redrafted to include the phrase that the OUR proffered.
Support.
Okay.
Noted, member.
We move to section 18, subsection 4. The OUR, in its comments, said that the earlier comments on the provision of section 18 regarding the proposal to delete references to supply and include references to all licensees who are authorized to purchase electricity are applicable to subsection 4 as well. In section 18.4, it is suggested that the reference to sale or other supply of electricity be removed and replaced with a reference to sale of electricity, and the reference to single buyer either be replaced with supply licensee or the latter term added to the provision. For example, so the current provision reads, notwithstanding subsection 2, and subsection 2 is the provision that we discussed above, which requires a self-generator to enter into a contract for the sale or supply of electricity and to be a holder of an electricity license. Subsection 4, as is currently in the Electricity Act, says, notwithstanding subsection 2, the minister may, in writing, where he is satisfied that it is in the public interest to do so, authorize the sale or supply or other supply of electricity by a self-generator to the single buyer, pursuant to an agreement approved by the minister in circumstances where the requirements of subsection 2 are not met. OUR is proposing a redraft as follows. Notwithstanding subsection 2, in circumstances where the requirements of subsection 2 are not met, the minister may, in writing, after consultation with the office and considering the office's recommendation, authorize the sale of electricity by a self-generator to the single buyer, a supplier licensee pursuant to an agreement approved by the minister where he is satisfied that it is in the public interest to do so. Now, subsection 4 here allows the minister to authorize the sale or supply of electricity by a self-generator to the single buyer, where the self-generator does not have an existing license or a contract, which might be a standard of a contract under a net billing arrangement or a wheeling contract under a wheeling arrangement. So this appears to be a special circumstance in which the minister may authorize the sale or other supply to the single buyer from a self-generator. We do not agree with removing the single buyer, and even though the Electricity Act contemplates that there might be more than one license issued for the activities that JPS have exclusivity for under the Electricity Act, we do note that because the policy is that the single buyer model be retained for now, subject to our revision of the license and the whole electricity structure as the date of expiry of the electricity license approach. And for that reason, we do not support the removal of single buyer. In relation to the reformulation, we maintain our view that other supply should remain because it might very well be that a self-generator may not have a wheeling license and may need to get power from its location to another entity which it has controlling interest in. And therefore, we do not want it to be a case where that may be prevented if we should accede to the OUR's proposal. Now, subsection 5 gives the minister discretion prior to making the decision in subsection 4 whether or not to authorize the sale or supply of electricity to consult with the office. We also believe that it should be retained. The OUR in its reformulation here at 18.4 brought that provision up, but requiring the minister to consult before. But it is no different from subsection 5, which allows the minister, which gives the minister the discretion to consult with OUR, and the public interest will favor any such consultation with the OUR, given their place as a regulator in the industry. Yeah. Should I proceed?
Go ahead.
The OUR is recommending that subsections of 18.6, 7, and 9 that they be pulled out and included in a discrete section on wheeling, or they remain as subclauses of section 18. We agree with the proposal, and we also agree generally for the subsection, for section 18 to be redrafted to include the specific arrangements for self-generation, wheeling, net billing, auxiliary, and the special circumstance at 18.4. And there is also at subsection 8, the authorization for the minister having regard to the integrated resource plan, the size and efficiency of a cogeneration plant, and the public interest, prescribe excess capacity that a cogeneration plant will be permitted to supply to the system. That should be retained. So subsection 18, we agree should be rationalized and to provide to be separated into different sections for the different type of self-generation activities for which an electricity license has been issued, and also the two exceptions at 8, the two special circumstances at 8.4, 18.4, and 18.8. That's our recommendation.
Mr. Chair.
Go ahead.
Mr. Chair.
Yeah, go ahead. Go ahead.
Yes. Peter Simmons here from Legal Reform. I just want us to, I'm just trying to digest all of what OUR has recommended and also the response of the ministry. But I do think we need to bear in mind that supply is defined under the Act as activities involving the sale of electricity. So it does seem redundant to be saying sale or other supply. But if we look at, for example, even the definition of net wheeling, or net billing rather, or wheeling, or in particular, well, for example, net billing, it says it can involve sale or otherwise credited with the value of excess power. It uses the word power, not electricity. But then when you look at wheeling, it says where the self-generator provides electricity. So I'm wondering if we can't consider, rather than saying the supply of electricity, we couldn't say the provision of electricity. And that would take care of the concerns of the OUR. I can't speak to the other three cases. Well, 18.4 and 18.8 also says supply. She mentioned another auxiliary, which I'm not too familiar with. I'm not sure where that falls in the Act. But I'm just wondering if we couldn't say sale or other provision of electricity as an option rather than keeping or other supply, given the way supply is already defined under the Act. That's something for the committee's consideration.
Noted. Any comments on that? Okay, Ms. Campbell.
the private sector organization of Jamaica in relation to section 18, subsection 6. So they are proposing that the phrase more than 50% be changed to controlling interest in. The provision of section 18(6), for better context, says a self-generator who is the holder of a generation license and has paid the use of system charge may engage in wheeling for its or his own exclusive use, and in the event that a market study conducted by the office determines the need for additional capacity, that self-generator may engage in wheeling to an entity in which it or he owns more than 50% interest. Now, this is where the PSOJ is indicating that in the place of more than 50% interest, that we substitute controlling interest. We note the comment, but we believe that the more than 50% interest suggests that the wheeler should have a controlling interest in the entity that he wishes to wheel to. In our view, it's saying the same thing, and the current construct is clear that the wheeler should have a controlling interest in the entity in which he wishes to wheel to. The JPS supplied a comment on section 18(6). They propose to delete the word "and in the event a market study conducted by the office determines the need for additional capacity, that self-generator may engage in wheeling to an entity in which it or he owns more than 50% interest. So they are suggesting that that portion be removed from the act. So in our interpretation, it would prevent wheeling from a self-generator to an entity in which it has interest, controlling interest. The ministry agrees for the reason that the IRP accounts for the market study. And in this regard, it is recommended that the portion is deleted. A redraft is proposed as follows. A self-generator who is the holder of a generation license and has paid the use of system charge may engage in wheeling for its or his own exclusive use, and may engage in whaling to an entity in which it or he owns more than 50% interest. So I think let me rephrase, the extent of the agreement is to remove the requirement for the market study based on the proposal of the ministry. And so the determination as to whether or not wheeling to an entity in which the wheeler has controlling interest is permitted based on the information contained in the IRP and not in reliance on the market study and the current formulation as it. Should I continue, Chair?
Sure.
Chairman,
Right, member.
there's a point of order, considering at least two of us here, we do have another joint sitting of a parliamentary committee shortly. I was wondering if now could be a convenient time for us to look at the other date when we will be meeting.
Yeah. Yes, member. As a matter of fact, I didn't realize that you had it because we usually go to 12:30, push it to 12:30, but I understand fully you have another one. So you need to prepare and get something. Okay, so we'll stop that for now. And
I second that, Sir Chair.
Right.
Our function that started from 10.
Right. Okay. So the next proposed meeting date would be Thursday, May 18th, 2023. Ms. Beckford, is that 10 or 2? 10 o'clock?
10, Chairman, but if you wish, because we had blocked a date for cyber crimes, but now that you're finished with that, the 10th is also available of May.
Yeah, give me the 10th and the 18th for sure.
Okay, Chair.
Members, 10th and the 18th should put us at a far distance in terms of completion. So can we move for the
At 10 a.m.?
10 a.m. on the 10th of May and the 18th of May. The Thursday Thursday is the 18th. Thursday, May 18th. And the 10th would be what day, Ms. Bedford?
Wednesday.
Wednesday?
A Wednesday, Chairman.
Okay. So can we confirm that, members? And as we discussed, we will invite OUR to that meeting and to those meetings to deal with the specific matters and also continue with the committee until we conclude the review.
And we're still on for tomorrow?
Yes, tomorrow morning. That is the IRP at 9:30 at PCJ building. That's confirmed. That's what that's confirmed.
Okay.
All right. So thank you for that, Member Paulwell, and to all the members for allowing us to start on time, and of course the support staff, and of course MSET team, Ms. Campbell leading today, and Mr. Brian Richardson. So I think we're making progress. We still have to deal with the SEZ matter. and find a way forward in terms of getting that and to bring it to a conclusion. But we'll continue on that. And by the next meeting, I'll have a further update for you on that. All right, so please enjoy your lunch. It's 12:09. So I move for the adjournment of this meeting to be reconvened on the Wednesday, the 10th of May at 10 a.m. and then Thursday, the 18th of May at 10 a.m. Until then, keep safe and thanks everybody for their cooperation. All the best.
The best, Minister.
Chair, thanks everyone. All the best.